21st, 2014, and this is the fourth or fifth of the SDRAFocus webinar series for self-directed retirement account owners. Today we have a lot of material to discuss, so I'm putting everybody on mute so we can get through it all. We may not have time within the hour to answer questions, so feel free to call me whenever you want to if you have questions about the materials that we talk about today. Now, the reason that we're talking about beneficiary designations is that that's what deals with what happens after the owner of a retirement account dies. And when there is that kind of a transition, if the retirement account has an interest in a business entity, then there are business succession issues for retirement accounts, just like there are for individuals. So today, today our agenda is to talk a little bit about IRA beneficiary designations and how they work, a little bit of a primer, and then there are a couple of main issues that I want to cover. One has to do with the control challenges when a self-directed retirement account owner dies and his or her retirement account owns a single-member LLC, and the other is what happens if there are multiple member LLCs in terms of what are the challenges that a self-directed retirement account itself has that owns an LLC when its owner dies. And if we have time, we'll go over some questions. So let's talk first about retirement plan beneficiary designations. What I find is that people get a little bit confused about this, but they really don't realize how much they know. And you know more than you think. So you know who owns your IRA account, and you also know when you pay income tax on it. That's if it's a traditional IRA, that's when you start taking minimum distributions, and if it's a Roth, it's when you create the Roth. You're creating it with after-tax contributions or a Roth conversion. You know that there are penalties for early distribution, and you know that there's a time when you do have to start withdrawing it after age 70 and a half. So those are the fairly easily known basics. But what a lot of people don't realize is that's really important is that distributions from retirement plans are controlled by beneficiary designations. Of course, everybody knows that, but not by your trust and not by your will. It's the beneficiary designation that really controls how retirement account funds are dealt with in terms of coming out of the retirement account. But the trusts are really important, and we'll get to that. So there are really just three types of designations. There are designations to individuals, there are designations to trusts for individuals, and there are designations to anything else. And by that I mean it might be charities, it might be a business entity, it might be a trust that doesn't qualify as an individual, and some other things. So we'll go over that now. So here's our 10-minute technical review of distribution rules. So there's really just three things to remember, and that's as easy as blue, yellow, green. Now here what we're talking about is the income tax deferral, which you get when you leave money inside your IRA or in your retirement account, because the income that's earned by your investments in the account typically are not taxed until you actually take the funds out. So what we mean by it's easy as blue, yellow, green is that there's three different tables. There are two different tables, I'm sorry. There's the true blue table, and that's the uniform table for withdrawals during your lifetime. And I'm going to see if I can show that to you. Here it is. Here's the uniform lifetime table. That's the table that applies to everybody starting at age 70 and a half. And that's the uniform table. So, and notice that every year you get older doesn't mean that the distribution period and the divisor that has to be used to determine what comes out of your retirement account as a minimum actually doesn't go down 1 year. It actually gets recalculated based on your life expectancy every year. So, what happens, what yellow means is that it means caution. If you name a trust as the beneficiary, you have to take a test to determine how fast the distributions are required. And then if you pass the test, then green means go, and you get to use the beneficiary's life expectancy. And that's what we refer to as the stretch out, because although you can take out as much as you want when you're the beneficiary, you have to take out minimum distributions. If the minimum distribution is less than what the growth is, you can see that the account is actually going to grow even though you're taking out distributions. So if you have a beneficiary who has a life expectancy of, let's say, 50 years, and that year they don't need the distributions from the retirement account, they only take out 1/50th of what's in the account, then that is going to be a lot less than how the income and growth of the principal at least should be if it's invested correctly. So if you get to green, that means that you're using the stretch out, and the beneficiaries' distributions are really not going to start overtaking the growth and the income until they get to be about 65, and that's when they need the money the most. And so during their lifetime, the account is going to grow, and that's what we mean by the stretch out. And it's important for planning purposes to try to preserve that. So what if you don't meet the test? Well, if you've started making distributions, whoever takes distributions from a retirement account after you die has to use your own life expectancy. And since you're typically going to be a lot older than the beneficiary, that's not an advantageous result. In order to get the income tax deferral we want, to get the personal instructions and personal protections that we'll talk about, we have to pass the test. So the same test applies for trusts, it applies for individuals, and it applies whenever the participant dies, whether before or after distributions begin. So if death occurs before you begin distributions, you have to pass the test, or the general rule applies. And the general rule requires that all proceeds from the retirement account be distributed within 5 years. If death occurs after you begin distributions, you have to pass the test, or the general rule applies, and that rule requires that the proceeds be distributed based on the account owner's remaining life expectancy as of the date of death, which could be quite short. So either one of those results, depending on whether you died before you start taking out minimum distributions or after at age 70 and a half, the rule as to how quickly the money comes out of the retirement account for your designated beneficiary is not advantageous unless you pass the test. So that means that, well, I just said this, so I'm going to go on. So here's what the test, and remember that there are 3 challenges to passing most tests. First of all, you have to know the material. You have to study, you have to get a tutor, or you might use both. Second, you have to show your work. And third, you have to turn your work in on time. So assuring distributions are based on the favorable life expectancy. We have to name somebody who is what's called a designated beneficiary. And that is a term of art. And what we mean is it has to be somebody who is an individual. In other words, we use this test called the heartbeat test. If your designated beneficiary does not have a heartbeat, then they can't qualify for the special treatment that allows them to take the stretch out and distribute over their life expectancy. So we have to be very careful about how we qualify our designated beneficiaries in order to make sure that we can pass that heartbeat test. So what this does is it allows the distributions to be based on the beneficiary's life expectancy, and it's easy when the beneficiary is a person. But if the beneficiary is a trust, there's a 5-part test to determine whether we pass the heartbeat test. So, because after all, a trust in and of itself doesn't really have a heartbeat. And what we're trying to do is to be able to look through the trust to the individual beneficiary to find a heartbeat. So in order to do that, there's this 5-part test that's imposed by regulations by the IRS. The trust has to be valid under state law. It has to have individual beneficiaries. The beneficiaries have to be identifiable based on the document. The trust has to be delivered to the retirement account administrator, and the trust has to be irrevocable upon death. Those are the 5 tests. So if the trust qualifies, then it becomes invisible, and all the beneficiaries are considered designated beneficiaries. In other words, they've passed the heartbeat test. And you can look through it to see the beneficiaries and use their life expectancies. So what are the obstacles? Well, the first thing is that providing lifetime protections and increasing this, these are the two challenges for retirement planning, or retirement account planning, is providing lifetime trust protections for individuals and increased stretch out capability. So what are the protections? A lot of people say, well, why wouldn't I just designate my child or somebody who's younger than me as the individual who's the beneficiary? Well, if you think about it, most people have problems during their lifetimes of one type or another. They might end up with creditors that are after them. They might end up with a divorce, and they might have problems with their assets that way. Or they might have a potential illness that means that they need help in terms of Medicaid or whatever it might be, and you want to protect the assets from their high bills, et cetera, from the illness. And we have a story called the school bus story. I won't go into it too deeply, but essentially the hypothetical is that I die. My wife, subsequently, who I give all my property outright to, has a school bus accident. And then the question is, what happens to all the assets that I gave her? All those children on the school bus are plaintiffs, and they're very sympathetic ones, so it's very likely that all of the assets disappear to her creditors. Well, if there's a way for me to give the property to her in a way that it's not hers, so the school bus creditors can't get to it, or divorcing spouses, or creditors from an illness, then that would be a big protection for her, and frankly for any beneficiary. So now for IRAs, everybody knows that there's been a recent Supreme Court decision that says that the IRA itself has protection from creditors, and so, but the problem is that the distributions from the IRA are not protected. So all the creditor has to do is simply wait around for the distribution and collect. So there's got to be a way for us to protect those distributions so the creditors can't get to them. And by the way, the Supreme Court decision is kind of limited because it only applies to the amount that's reasonably necessary for the retirement needs of the beneficiary. So nobody really knows what reasonably necessary means. It would be their facts and circumstances. But if you have a multi-million-dollar IRA, it's less likely that all of it will be protected from creditors under state or federal law. So why pay distributions to a trust? And that's to provide those protections. So there's also another reason. That's to pay distributions to the trust to get financial instructions followed. First of all, if the beneficiary does not understand about the potential for income tax deferral or the stretch out, then it's important for the trustees of a trust or someone who's involved in the trust to teach them, particularly if they're young or underage. And also, it's important for the trust sometimes to have people be able to control and direct the deferral, particularly for people who are underage, or might have other disabilities, or they might be spendthrifts, who knows. So that's important. But remember that, for distributions in IRAs, minimums are minimums. So there are minimums for you, and there are minimums for your beneficiaries. Minimums means that you have to take out this amount, but it doesn't mean you can't take out more, so you can take out a lot more. And it may be that the beneficiary doesn't need the money, but if somebody calls them up and says, I've got this retirement account for you with all this money in it, the next thing they might say is, okay, send me a check, in which case they no longer have the option to stretch the money out and let it grow tax deferred. So then, of course, there's also the question of investment philosophy. If a person is unsophisticated in investments or in business affairs, they might need someone to help them with the investment philosophy. And then there needs to be an investment policy that's adopted in order to decide how that works. So why pay distributions to a trust? There's also death tax planning. And that means using the marital deduction or using the estate tax credit. And that can be made available through the use of IRA funds, but only if the distributions are payable to a trust and only if there's been some planning in advance. So what are the distributions that drive our decisions for distribution goals? Well, first of all, do we want to provide protections? Do we want to provide instructions? Do we want to use each individual's beneficiary's life expectancy for distributions? And if all of those are true, then we're probably going to use the trust. So, when would you not want these protections for your beneficiaries? Well, some people would say, all right, well, I don't really want to put strings on it. But when we ask them, when is it okay for a divorcing spouse to get the money that you left to them, they'll usually say never. Or when is it okay for this money to be spent before they can qualify for Medicaid? Most people would say never. Or when is it okay for their creditors to get the money instead of them? And the answer would normally be never. So most people, when they understand those circumstances, decide that they would like very much to have the protections that are afforded by trusts. So, and that's going to become important when we talk about the control challenges that happen when we use self-directed retirement accounts, particularly in a small LLC. So the first set of challenges has to do with single-member LLCs. All right. The problem is, okay, so who fills the empty chair if the retirement account owner has made an investment in a limited liability company? And let's assume that the retirement account owner is the manager of that LLC, and it's a single-member LLC. That means that the retirement account owner has some sophistication and knowledge about this private investment that's been made. That sophistication and knowledge may not be available to the beneficiary that they've designated, and so when something happens to them, we have an empty chair in controlling how the IRA's decisions are to be made. All right, and then of course there's also the question, if the IRA owner is the manager of the LLC, there's the serious question about who becomes the successor manager. So here we have a typical situation. We have a self-directed retirement account investment limited liability company. The self-directed retirement account owner has died. And so now you can see the picture here. We've got the LLC. The IRA owner here is right here. See if I can get my drawing tool to work for me. Here's the IRA set. The self-directed retirement account is now the member of the LLC, but the original owner no longer directs it. Here's Pensco as the self-directed retirement account custodian, but of course they specifically provide in their documents that they don't make decisions like who controls, who makes these decisions about what's inside the self-directed retirement account. And then we have the beneficiary. If the beneficiary is not qualified or doesn't understand how to do this, are they qualified to be the manager of the LLC? Are they, what are they qualified to do? Can they direct the investments that the LLC is supposed to do? Can they make decisions about that? Oftentimes that's something that beneficiaries aren't really able to do. So, what happens then if we have a trustee in the middle? So here's the situation for a self-directed retirement account. We've created a trust for the beneficiary, and the trust is the beneficiary for the retirement account. And here we have an individual beneficiary, so we know the trust is invisible as far as minimum distributions are concerned. So let's say this is a minor down here as a beneficiary. The trust has trustees that are able to make decisions and direct Pensco about how the self-directed retirement account is to be invested, and they can designate who the manager of the LLC can be. And that helps protect the beneficiary. And so, who would the trustees be more qualified to make these decisions than the beneficiary? And if the answer to that is yes, then clearly one of the best solutions to who the beneficiary should be is the trust. So, a lot of people would object to this on the basis of, well, all right, but, my beneficiary has no control. Suppose they grow up, or suppose they're qualified when I die to run everything. but we want the protections and that kind of stuff. What happens? Well, the easy answer to that is, well, what if the beneficiary were a co-trustee? And what if the beneficiary were able to select the trustees, to hire them and fire them, as long as he or she had a co-trustee? That might work very well. So that way we can make sure that the beneficiary not only has some fairly functional control over what happens and who the trustees are, but also they get the benefit of the protections of the trust. We no longer have an empty chair, and decisions about the investment can be made. So then we have a whole set of issues about what happens when the self-directed retirement account owner dies and we have multiple members in the LLC. So many times when we're looking at operating agreements, there are a few specific things that we need to take a look at to make sure that they're properly written and accommodate what happens when there's a retirement account member. So do the changes in beneficiary designations trigger transfer restrictions? Many LLC operating agreements will almost automatically say that you can't transfer your interest in the LLC without the approval of the manager and oftentimes the other members. Well, if we change the beneficiary designation, does that trigger the transfer restriction? Unless the specific provisions of the LLC qualify, that might be a question. Typically, people would say, no, the beneficiary designation isn't irrevocable. It can be changed any time. That's just part of the paperwork, but the real functional control during the IRA owner's lifetime is really in the IRA owner that made the original decision and that people regard primarily as their partner or co-member. So, but what about the death of the IRA owner? Does the IRA owner's death trigger transfer restrictions? Well, typically in a retirement account, in an LLC operating agreement, the death of a member does trigger some form of transaction. But if the IRA owner has set up a plan and wants to be able to sell their LLC interest to third parties if they're available, the LLC doesn't want unidentified third parties coming in and buying the interest of the deceased member. So there are restrictions on when and how they can be sold, and often the result of those restrictions is we have two different types of arrangements for the purchase by other members. One is the cross-purchase arrangement, where co-members of the LLC have the right and ability to purchase the unit at a specified or negotiated price. Or we have redemption agreements where the LLC itself might redeem the units at a specified price based on agreements between the members. So let's take a look at a couple of diagrams. Here we have a multi-member LLC, and during the self-directed retirement account member's lifetime, we have, here's the retirement account member right here, and we have the retirement account owner as a member. Sometimes we're co-investing. And then we have a couple of third parties that are unrelated to the retirement account or its owner. Then, of course, we have the SDRA owner over here as the beneficiary, current beneficiaries of the retirement account, and PENSCO as the custodian. So what happens when the retirement account owner dies? So here's what happens. Well, now we have the self-directed retirement account owner, and they become, it's their estate. Typically, it might, if they've done estate planning, it might be a trust. It might be their probate estate, and many people are trying to avoid that. But we have the self-directed retirement account owner's individual units that are owned by his or her estate. It might be a trust or the estate. Then we have the self-directed retirement account member, and something now happens to that, and what happens is that it still continues to own the LLC interests. There's no title change there. PENSCO still owns it, but there's a new beneficiary. PENSCO as the custodian still owns it, okay? But there's now a new beneficiary. And that's the situation that's arisen. If this beneficiary is in control of what happens with these LLC interests, the other third-party unrelated members may have a concern. If they don't like that person, or if that person is is unqualified, or if they can't support the financial obligations or something else, then they'd like to get rid of that beneficiary, and that's what cross-purchase agreements are typically about. So what happens then is that we have to sell the self-directed retirement account members' interest. That's the IRA's interest in the LLC. So can the self-directed retirement account's owner's estate buy it? Well, the answer to that is no, because it's an estate for the benefit of people who are disqualified, typically closely the beneficiaries of the IRA, or it might be other family members, but typically that's a trust or an estate for the benefit more than 50% of people who are disqualified persons. So that makes this buyer over here, the self-directed retirement account owner's estate, a disqualified person. So he or she can't buy the self-directed retirement account member's interests. That the estate can't buy that. There can be no transfer here. All right. What about the third-party members? Well, these people typically would be looking forward to being able to buy both the self-directed retirement account owner's estate from the estate and or from the retirement account itself. All right. Well, can they do that? That's really, unfortunately, just a maybe, because here's what happens. Let's say that the self-directed retirement account owner and or his or her family members owns 50% or more of the LLC. Okay, and let's say that these third parties over here are really, they own 10% or more each. So what happens then is that if the LLC is owned by a person who's a disqualified person, all right, that's the self-directed retirement account owner and his or her estate, 50% or more, and these third parties are 10% owners of the same LLC, they become disqualified persons as well. And that doesn't work very well, because that means that not only is the retirement account owner's estate unable to buy out the retirement account's ownership interest, but the rest of the members cannot buy out the IRA's owner's estate either. Not a satisfactory result for most people. So can the LLC buy out the self-directed retirement account member's interest, all right, the IRA member's interest? Well, all right, that depends. So what are the factors? Well, first of all, what if the self-directed retirement account owner and or family members owns 50% or more of the LLC? Well, the LLC is a disqualified person with respect to the retirement account, because it's an entity that's owned 50% or more by disqualified persons. So, what happens then? Now we have a situation where the IRA member, the self-directed retirement account member, not only can't sell to the other members of the LLC, it can't even sell to the LLC itself. Seems like kind of an absurd result. And most of us would say that the solution to most situations like that is that the IRA member's interest at a fair and reasonable price gets liquidated or redeemed by the LLC itself. In other words, they have a complete liquidating distribution. All of their interest in the LLC is, the value of their interest is completely liquidated from ownership in the LLC, and so that would be the solution typically. If we can't do that, then we probably also can't have distributions payable to, we can't co-invest at all, because in that situation, if the if the owner of the IRA is a 50% or more interest owner of the LLC, the owner themselves makes it a disqualified person, and theoretically, we can't even get distributions of income to the IRA member. That's not a result that anybody would anticipate, and there's so many regulations that suggest that you can co-invest. It seems kind of strange to be able to say that the IRA can't even liquidate its interest at a point where it now becomes advantageous or even a prohibited transaction for it to continue. So we have to say that depends. This is one of those unfortunate issues that seem unresolved at the moment under the law. So what do we do about that? Well, the first, of course, issue, if we want to cross-purchase, what we really could do, particularly if the LLC is owned 50% or more by disqualified persons, what we really want to do is we want to request an exemption from the Department of Labor. Now, that may take some time, but if the Department of Labor regards it as qualified under the regulations for it to give an exemption, then that's not too hard, particularly if you can show that the value is correct and that we're trying to resolve a situation where we're trying to liquidate a member's interest. Even if it is a disqualified transaction, we might get an exemption from the Department of Labor. Another solution, particularly where the self-directed retirement account owner, or the member, the IRA member, owns 50% or more, is we could request, because we don't know, by the way, if the IRA owns 50% or more of the LLC, we still don't know, although cases seem to suggest that this is true, we still don't know if the LLC becomes a disqualified person with respect to its IRA owner. Remember, that's the Sullivan case because they have that footnote, and there's some other cases that have sort of followed the same language but not actually held that. So, you know, here we are. We've got the self-directed retirement account. It owns an interest in the LLC, 50% or more, and we need to get out. So we might ask the Department of Labor either for an exemption or we might ask for an advisory opinion from the DOL so that they can tell us. Now, what's the advantage of those two? Well, if it turns out that IRS audits the transaction or third parties say that there's been a prohibited transaction, so the IRA is disqualified, we have our exemption or we have our advisory opinion to stand up and say, no, these are perfectly okay. Because the Labor Department has the ability, of course, to do advanced rulings about the qualification of some kind of a transaction under Section 4975. So that's a couple of solutions that we could get, and we could get the estate to apply for that kind of thing. But, you know, why would we do that? Well, the first thing, if we had third parties who are not disqualified persons, they could purchase the self-directed retirement account owner's interest first in the LLC. All right, so now what we've done is we have the IRA owner, we have the third parties, but we no longer have the self-directed retirement account owner's estate owning the LLC. Well, at that point, these parties over here are no longer the co-owners, 10% or more, of an entity in which the fiduciary or the disqualified person owns 50% or more. So they now become qualified people. They're no longer disqualified persons, and that allows them, after this first transaction's occurred, to purchase the self-directed retirement account member's interest. So now they can get both of them out, and now they own the LLC. Now that, you know, that can be a helpful transaction. We have some concerns about it because it might be a step transaction. You know, IRS has these rules about step transactions that say, you know, even though you can see on paper that it looks like they're okay, if it's part of an overall scheme that's designed to avoid taxes, then it might be a step transaction and might be considered the same as if the transaction had all happened at the same time. But, you know, that is one possible solution. And again, we might ask for a Department of Revenue exemption or Department of Revenue advisory opinion for that. But also, we might also, if we wanted to, and that's quite a bit more expensive, go to IRS and ask them for a ruling because they can rule on stuff like some of that information. Well, what about a redemption? And what we're talking about here is the LLC redeems the self-directed retirement account's interest in the LLC. Okay? Well, if the LLC is a disqualified person with respect to the retirement account, you know, we have those same kinds of issues that we had before. You know, if the self-directed retirement account owner, the account's owner is a 50% owner or more and their estate is, then this is a potentially disqualified person, the LLC is, or you know, there's that theory that the retirement account itself can make its own holdings a disqualified person with respect to itself. Of course, you all know that I think that's an absurd theory. But in any event, so how can we do that? Well, again, we can request an exemption, we can request an advisory opinion, or we can redeem the IRA owner's interest first, so that at the point where we actually redeem the self-directed retirement account or the IRA owner's interest, the LLC is no longer, assuming the IRA is not a 50% or more owner, the LLC is no longer a disqualified person. So that might work. So, but there might be another way. And here's where trust really can be helpful. Let's say that we set up an insurance trust, and that's a trust that is on the life of an individual, and it holds insurance and it is the beneficiary of the policy, and the policy is on the life of the individual person who created the trust. So the insurance trust, at the death of the IRA owner, owns this policy and receives the policy proceeds, makes the claim on the policy. All right? And then it purchases an interest in the self-directed retirement account, in the LLC itself, using that money. Well, that's extra cash that the LLC can use to liquidate the interests of the members that are being redeemed. All right, but remember, we can make the IRA owner, the beneficiary of the IRA, the designated beneficiary of the IRA, that's this guy over here. We can make him also him or her also the beneficiary of the insurance trust. So they've got the best of both worlds. They've got the cash coming in here to purchase to buy interest in the LLC, and that allows the LLC to liquidate the cash. And then they end up with the cash in the IRA, and we can designate the trust as the beneficiary of the IRA instead of the individual. So the individual ends up getting the best of both worlds. We have the insurance, we have the trust itself for the benefit of the beneficiary as the beneficiary of the IRA, and we also have the LLC interests owned by the trust itself. And so that's not a bad solution. So if there's anybody on the line at this point who'd like to ask any questions, I'm going to unmute everybody. And you know, if anybody would like to ask any questions, feel free to come on. Of course, if there are no questions, we can conclude. And I'll be sending out. We're recording this, so we'll be sending the link out to the presentation for everybody. Well, if there are no questions, and I don't hear any, then we're going to conclude the conference. And thank you all very much for listening, and have a great day.
Thanks, Frank. Bye-bye.